Welcome back. The Attorney General and Minister for Justice, Mr. Abubakar Malami, SAN, has been speaking about the impacts of public corruption and the connivance of financial institutions in the thriving crime of illicit finance flow out of the country. He spoke at a news briefing in Abuja on Thursday.
Thank you very much, ladies and gentlemen.
Members of staff and top officials of the Federal Ministry of Justice, as well as heads of various agencies and parastatals under the supervision of the ministry, gathered here on the first day the Attorney General of the Federation, Abubakar Malami, resumed office, following his reappointment by President Muhammadu Buhari. In his remarks to the gathering, Mr. Malami says that for the next 4 years, his ministry, in collaboration with anti-corruption agencies, will beam a searchlight on financial institutions encouraging corruption in the country. He was speaking against the background of the recent award of $9 billion by British courts against Nigeria.
Sadly, in spite of the spirited and concerted efforts of the current administration to combat corruption and rent-seeking in all its forms, Nigerians woke up unfortunately on Friday, 16th August 2019 to the rudest consequences of the underhand dealings of the first administration that has resulted in the award of $9 billion judgment against the Federal Republic of Nigeria by a British court, which ruled that Process and Industrial Development Limited had the right to seize 9 billion naira in Nigerian assets. It may interest you to know that the dispute that led to the arbitration between the federal government and P&ID, which consequently resulted in the said court ruling, arose from a 20-year gas supply processing agreement purportedly entered with P&ID by the first administration in 2010, which contract P&ID never performed as agreed.
The minister also spoke about the need for judicial reforms.
May I inform you that the major reason for the seeming failure of our system is the structural defects of our constitution and laws, non-adherence to laws, institutional failure of enforcement, and dysfunctionality of our judicial system, which only judicial reforms can reverse if we must exist as a nation. The government shall be activating sacrosanct provision of Section 15 of the Money Laundering Prohibition Act 2011 as amended against private individuals and corporate entities culpable of concealing, disguising, converting, transferring, hiding, removing from the shore of Nigeria, acquiring, using, retaining, or taking possession of control of any fund or property they knowingly or reasonably ought to have known to have formed or forming part of the proceeds of an unlawful act. As bad news to the rogues within our financial system, in the next 4 years, the Federal Ministry of Justice, in collaboration with anti-corruption agencies, shall be beaming anti-corruption searchlight on the financial institutions and non-designated financial institutions in order to make them pay dearly for the dastardly role they have played and are still playing in encouraging and deepening corruption in Nigeria. From arms of procurement, fraud, INEC bribery case, to the Zani case, and still others, quantitative data available to the federal government abundantly shows that financial institutions are directly involved in most of the major corruption cases investigated by the Economic and Financial Crimes Commission and Independent Corrupt Practices and other related commission, ICPC, from 2015 till date. Financial institutions will henceforth be part of the prosecution in respect of any financial illicit flow arising from money laundering offenses in this nation of ours.
It would be interesting to see how the government tackles these issues in the next 4 years, especially against the background of another charge made against some 80 Nigerians by the FBI.
And on the home stretch, let's bring you a recap of some of the top stories we tracked at the courts.
We begin with the report that the Presidential Election Petitions Tribunal has reserved judgment in the suit filed by the presidential candidate of the People's Democratic Party, former Vice President Atiku Abubakar, challenging the election of President Muhammadu Buhari. A five-man panel of the Presidential Election Petition Tribunal, headed by Justice Mohammed Garba, reserved judgment to a date to be communicated to all parties involved in the petition. Counsel to the petitioner in his final written address says that President Buhari's claim that he submitted his certificates to the military board had been controverted by the secretary to the military board. Lawyers to INEC, President Buhari and the All Progressives Congress, however, urged the tribunal to dismiss the petition with substantial cost for lacking in merit and substance. They argued that the nation's law only requires a candidate to be educated up to secondary school level or its equivalent. In yet another petition, the Presidential Election Petitions Tribunal has dismissed the petition of the Hope Democratic Party challenging the victory of President Muhammadu Buhari and the February 23rd presidential election. The presidential candidate of the HDP, Ambrose Oburu, and his party had on March the 7th filed their petition seeking the nullification of President Buhari's election on grounds that the election conducted by the Independent National Electoral Commission was illegal, null and void on account of its postponement from February the 16th to the 23rd. They also asked the five-man panel to declare them the winner of the election, having been elected president by 50 million Nigerians through a referendum conducted on February the 16th. They specifically asked the tribunal to order their inauguration as president within 48 hours of hearing their petition based on the referendum. Delivering judgment on Thursday in Abuja, a five-man panel of judges led by Justice Mohammed Garba dismissed the petition in a unanimous decision. According to Justice Garba, the said referendum was outside the jurisdiction of the tribunal, whose duty was to determine whether a person was validly elected into the office of the President of Nigeria or not. He said the petition, which also challenged the postponement of the presidential election, was at best a pre-election matter and ought to be presented at the federal or state high court and not the tribunal. Away from the presidential election petition, a federal high court in Abuja on Monday the 19th of August struck out an application seeking to stop President Muhammadu Buhari from inaugurating the 43 ministerial nominees over alleged deliberate exclusion of an FCT indigent from his ministerial list. Justice Taiwo in his ruling dismissed the application on the grounds that the court lacks the power to grant an interim injunction where the applicant has failed to establish his legal rights in the matter. The applicant, Musa Baba Panya, who is also the counsel in the case, had approached the court with an ex parte motion asking the court to stop the president from going ahead with the inauguration. Mr. Baba Panya, who is also an indigent of Karo in the Federal Capital Territory, in his suit argued that the president's action was contrary to an appeal court judgment delivered on March the 15th, 2018, but the Federal High Court struck out the case. In Kogi State, the National and State Assembly Election Petition Tribunal has quashed the victory of Senator Dino Melaye representing Kogi West Senatorial District. Senator Melaye of the PDP was declared winner in the February election by INEC, but Senator Smart Adeyemi of the APC approached the tribunal, challenging INEC's declaration on grounds of irregularities, overvoting, and non-compliance with the Electoral Act. The three-man panel, led by Justice A.O. Chijoke in a unanimous judgment on Friday, accepted Adeyemi's ground and ordered fresh elections in the senatorial district. And we round off with the report that the former Minister of Petroleum Resources, Diezani Alison Madueke, has challenged the seizure of $40 million worth of jewelry from her premises by the Economic and Financial Crimes Commission. In an affidavit filed on her behalf by her counsel, Professor Awakalu SAN, Diezani, who is currently in the United Kingdom, alleged that the EFCC violated her fundamental right to own property and to appropriate them at her discretion under Sections 43 and 44 of the Constitution. She also accused the anti-graft agency of entering her apartment illegally and taking the items without any court order. After granting an interim forfeiture order for the jewelries on July the 5th, the court adjourned till August the 19th for Diezani or anyone interested in the jewelry to appear before it to give reasons why the items should not be permanently forfeited to the federal government. But in an application filed on her behalf by Kalu SAN, Diezani contended that the court lacked jurisdiction to have granted the interim forfeiture order in the first place, as she had not been charged with any crime or served with any summons by the EFCC. The court has adjourned the case till August the 29th.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shayeli. See you next week.